ERP litigation has exploded over the last few years, and while every case is different, the legal structure and the claims in every one of these lawsuits is similar. That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For over 20 years, I have drafted and negotiated a variety of technology-related contracts and litigated failed software implementations in courts across the country. So let's start where every ERP implementation begins, and that is the contract. And what we see in the lawsuits that we litigate are contracts that are one-sided, unreasonable, and really don't provide much contractual relief at all, and be assured that is by design. The approach that these vendors are taking to their contracts and the contract negotiation, the contractual framework, really is akin to kind of a take it or leave it scenario. And while that's not necessarily true, I think you have more leverage than you might think you do. It certainly depends on how much money you're spending, how long the length of the term for that SaaS product is going to be. The unwillingness to negotiate, I think, has really come to the forefront over the last, I'd say, 5 to 7 years. Back in the old days, certain vendors were really willing to engage with you and put in place more of a balanced contract. And I think today, you've really got to go through these agreements. You've got to know what the negotiation points are. You have to understand what a reasonable ask is, what an unreasonable ask is. You can't make that analysis without context. I mean, you've got to have an understanding of what that vendor is likely to agree to based on, past performance, past experience with negotiating with that vendor. You need to utilize third-party consulting firms like Gartner, or there's others that are going to be able to tell you this is an issue, this is what we see customers get. You want to engage a law firm or an attorney that practices in this space regularly so that they've got a good baseline for, not only what's reasonable commercially to ask for in the software industry, but, what is Microsoft Dynamics likely to give you versus Oracle versus NetSuite, and then compare that to SAP. Every one of these vendors is different. Every one of them has pain points and pushbacks that are going to be unique to them. But I think the commonality that they all have is that their initial pushback or stance on these agreements is, we can't do a one-off change to this contract for you because this is a product that is standardized and pushed out to our entire customer base. So having one-off obligations doesn't really make sense. And I will tell you not to believe that. That is an unreasonable position for them to take. What can you negotiate? What can you push back on? It's really going to depend. The goal here and what you really need to be focusing on is putting in place as much as you can a contract that is balanced, that does not shift the legal burden of that relationship just to you. You've got to make sure that that vendor has skin in the game. And then when that project goes sideways, if it does, you've got at least a dog in the fight. You have some contractual remedies that are going to work for you. You're going to have the ability to hold that vendor's feet to the fire. The first takeaway from this is, with respect to the contract, don't sign the vendor's form just as is. You've got to look at that thing. You've got to push back. You've got to review it. And the goal ultimately is fair and balanced and flexibility. Count for revenue generating events, make sure you understand them, put caps on fees in that agreement, give yourself the ability to suspend support, maintenance, look to a third party, think about vendor transition when you're going off of that vendor. How are you going to get to the new one? What kind of access to your data are you going to need? What's the cost going to be for that? Reasonableness, flexibility, those are the keys. The other commonality that all these lawsuits really have when we're looking at the structure of an ERP lawsuit is some element of misrepresentation during the sales cycle, some element of fraud, some sort of overselling of the software. And I think this can take a variety of forms. I don't think, all these salespeople out there are trying to hoodwink you and they're trying to make claims that just are not true, they're not verifiable, and that, the software actually doesn't do what they say it does. But I think you've got to take a look at it holistically. I mean, they are incented by commission. The life cycle of one of these deals can be years. They have been working to sell multi-million-dollar contract or deal for 1 year, 2 year, 3 years, whatever it is. And now, at the end of that, they're going to get this large commission. They're incented to make it look easy. They're incented to sell you the sizzle and not necessarily the steak. Be assured that they are not going to emphasize how difficult the implementation is going to be. They're not going to get into the weeds with you about how complicated data migration is. They're not going to tell you the likelihood that the implementation is going to be over budget and take longer than expected is incredibly high. None of that's going to be disclosed to you. And I think you've got to know that going in. Now, the challenge is you can't protect yourself from dishonesty and you can't protect yourself from outright lies or fraud, right? We see incidents of vaporware during the sales cycle. We see certainly misrepresentations of functionality. We see people that do not care about gaps in functionality. They don't even care to minimize them. They just say they're not there, that the software can do all of these things that you want it to. We see demos that are skewed. All of these things happen on a regular basis. And when you're going into one of these deals, you've got to go in with your eyes wide open and understand that these salespeople are not on your team. It doesn't matter how much they seem like they are, you've got to be aware. So what else do we see? Well, we see scope creep and change order issues on a large scale. ERP projects are constantly evolving. You've got this obligation that maybe is in an SOW. You're going to use this software out of the box with no modification or no customization. And that's probably not realistic and it's probably not going to happen. There are always going to be unknown issues that arise. There's going to be gaps in functionality that were not accounted for. There are going to be issues that are going to require workarounds and creative solutions. And a lot of times those show up. They show up as scope creep to some extent. Ideally, this product has been mapped out. You understand where the gaps in functionality are, and you have an understanding of how you're going to address them. What will happen is there will be some sort of a misrepresentation in functionality, or there will be a misunderstanding with respect to functionality, and you've got to implement a workaround that was not expected. And then I think once you start doing that, it becomes easier to address even, small discrepancies between the new system and the legacy system. We've seen scenarios where a customer doesn't want to really adapt their business to the software, and instead they modify the software substantially in an effort to make it function in a way that is very consistent with the way the legacy software operated. And that, I think, is a problem. What we will see in the lawsuits that we litigate are overruns on the budget that directly result from scope creep and change orders, very high magnitudes. I mean, it's not uncommon for something to be 50% over budget in these lawsuits, cost twice as much as what was represented. If that happens, I mean, that certainly would suggest that any kind of estimates on the front end or representations regarding how complicated this was going to be were probably not on the up and up. They were misrepresentations, certainly. The other thing that we will see is data migration and integration failures. What happens often is data migration is really kind of an afterthought. If something is going to fail, it's not going to fail because the software didn't work. It's going to fail because of processes in the implementation or integration of that software. There's going to be a failure of governance of the project. There's going to be a lack of understanding of what contractual roles and responsibilities are, and data migration fits right into that area. It's often an afterthought. It's not clear who's going to be responsible for it. Vendors will typically wash their hands of it. Where it becomes an issue is nobody has devoted the time and man hours or has the interest in it to clean that data. You've got, what we call dirty data. And what that means is that, well, the way the legacy system operated with respect to balancing books, sending out invoices, or the way the invoices were structured, they may have fields and information that are not necessary in the new system, and that causes issues. And you go live, and now because the data was not clean, nobody paid attention to the data, you can't balance your books, you can't ship product, you can't invoice your customers correctly because there are substantive issues. And that may not be a software issue, but that very well could be a data migration issue and an integration failure. The other thing we see in our cases really has to do with the decision to go live and then post-implementation issues, trying to right side the difficulty that is associated with a failed go live. And so we will see customers that will rush to get ready for a go live. They will, instead of incorporating or integrating all the customizations or modifications that they needed into that software, they will be pushed by the vendor, or they will feel pressure internally to meet this go live date. And what they do is they end up with a minimally viable product that actually, gets them to the goal line, so to speak. But then, the reality is after go live, all these other customizations, modifications, and configurations are going to be done. And that really is not a good approach. We see that, like I said, on a very consistent basis and kind of on a surprising basis, where how often the go live date was rushed. There wasn't really an analysis of the go live decision. And then you see companies struggling just to survive on the back end of that go live date. You've got things like hypercare or post go live support that are intended to mitigate the stress and pressure of the go live. But if you don't do it correctly, it doesn't really make sense to rely on that kind of support because it's not going to be enough. The other issue that we'll see in the lawsuits that we deal with really is it's a contractual issue, but it really is framed as what's the exposure from a limitation of liability and a damages perspective to you as the customer and to the vendor. These contracts, again, are one-sided, unreasonable. They're very narrowly focused on the amount of damages that you can actually get, meaning that you're going to look at a damages provision that disclaims all indirect and consequential damages, and then the vendor is only liable for the amount of money that you spent in the last 6 months. Order form and an SOW, it's not all fees paid in the last year. It very well could be 6 months, and it's a subset of the contract. And that's not going to get you very far if you've got to litigate. And so what's the purpose of the litigation then? I mean, if you can't get your money back or any kind of substantial amount of money, I mean, you've really got to think about what you're doing and make that decision to litigate very carefully, because that really dictates the strategy of the lawsuit. It dictates how aggressive you can be. It dictates how you're going to settle that case. And so you want to make sure that you've thought that out pretty well, certainly before litigating, but as you're negotiating that contract. And we have tricks that we will use. We're looking at is trying to leverage these tort claims to get you out of the four corners of that agreement, including those limitations of liability clauses that aren't going to provide you with any kind of real remedy. The goal then is that if they've defrauded you, if they've made misrepresentations, then the contract becomes kind of secondary with respect to the limitations, because that was not part of the bargain for exchange. Expect for them to lie to you to get you into that contract. That's the way you can really try to hold these guys to account and hold their feet to the fire. The other issue that we see really is the difference between arbitration and litigation. Depends on, whether you're a vendor, whether you're a customer, depends on your past experience. And I don't think there's a right or wrong answer with one or the other. I certainly have my preference. If I am a customer, I usually prefer to litigate. I think that you've got a good, solid ability to appeal a bad decision if you get one. You've got more discovery devices that you're able to utilize to your advantage. You've got an experienced jurist that has probably seen multiple cases like this, unlike arbitration, where certainly you can pick your arbitrator. But I find is you've got arbitrators that are either retired judges or they're lawyers that are maybe in the fourth quarter of their career that maybe have not seen a lot of cases like this. Maybe they got general intellectual property experience. They've got general contract experience. A failed implementation is really neither of those, right? It's its own animal, and you really need somebody that's got substantive experience in dealing with these kinds of cases in the past. Some of the advantages, I think, of arbitration are, one, that it's confidential. There's no public record of it. I mean, I think if you're a vendor, that's great for you. If you're a customer, maybe that's good too, but there might be some advantage to utilizing the fact that this fraud allegation is out there in the public. You might be able to utilize that to your advantage. So, I don't think there's a right or wrong answer, but that really does kind of color how you're going to go about resolving this. And litigation is substantively different from arbitration. You've got to look at things that are going to impact that, like the governing law, the venue. If you're litigating against Oracle, you're going to be in Northern California. If you're litigating against SAP, you most likely are going to be in Philadelphia. There are substantive differences with those laws, and there's also a convenience issue too, right? If you've got to hire local counsel, you've got to hire an attorney that you trust, maybe you've got now a legal team that you're dealing with, and you've got to travel back and forth from wherever your corporate headquarters is to litigate in their home court, and that's not going to be advantageous to you. So, I think you want to think about those things before you litigate, certainly. So what are the lessons? What are the takeaways from this? Well, I think when you look across ERP cases, certain themes repeat themselves frequently. We look at scope and change management issues. Change management has broken down. Data migration, testing, those kinds of things are often afterthoughts. Clients that we deal with didn't pay enough attention to those. There's almost always some component of something being oversold or misrepresented. And there's always the issue of contracts being either vague, one-sided, or not negotiated at all. And so I think, the takeaway from this really is ERP lawsuits are complex. They're not like normal breach of contract cases. They're not intellectual property cases. But, the good thing is that while the facts of every ERP implementation are going to be unique, they're going to be different. The underlying issues from a legal perspective are almost always the same. And I think you want to get somebody on your team that has dealt with these things, that understands those issues and can leverage their knowledge and their experience to your advantage. If you have any questions about anything I've talked about in this video, please feel free to reach out to me. I'd love to talk to you and point you in the right direction.